So, hello ma'am, hello classmates. I am Mark Jason Ladisma, the third reporter of the Group 16, and the topic that I am going to tackle all about is the additional requirements prior to entry. So, additional requirements prior to entry. So, for the non-immigrants, a valid ticket for a return journey to the country of origin or to the next country of destination is required for presentation. So the certificate of residence must be secured by the following categories for non-immigrants from the Bureau of the Immigration. So this includes the temporary visitors or kanang tourists, so the students and the pre-arranged employment. So the foreigners entering as non-immigrant may also be required to register in the accordance with the provisions of the Alien Registration Acts as follow. So these are the categories that for the foreigners entering as non-immigrants in the Philippines. So the first one is any aliens who is in the Philippines at the time of the approval of the Alien Registration Act and who is 14 years of age or more and will remain in the Philippines for 30 days or longer. Next, any alien who enters the Philippines after approval of the Alien Registration Act of 1950 and who is 14 years of age or more and who will remain in the Philippines for 30 days or longer. So, provided that this provision shall not apply to an alien admitted into the Philippines for 6 days or longer. So the next is every parent or legal guardian of any alien child who is in the Philippines at the time of the approval of the Alien Registration Act of 1950 who is below 14 years of age and will remain in the Philippines for 30 days or longer. So next is every parent or legal guardian of any alien child who enters the Philippines after the approval of the said Act and who is below 4 years 14 years of age and who will remain in the Philippines for 30 days or longer, so provided however that this provision shall not apply to an alien child admitted into the Philippines as a temporary visitor or transient unless the said child will remain in the Philippines for 60 days or more. So every parent or legal guardian of any alien child born in the Philippines. Next, whatever an alien attains his 14th birthday in the Philippines. Lastly, it is imperative for government medical officers, immigration officers, and the Board of Special Inquiry to conduct a sufficient medical examination of all aliens arriving in the Philippines. So such examination is focused on physical and mental health or may extend on the Philippine inquiry on standards established by immigration law, rules, and regulation for entry and admission shall be included under Section 29 of the Immigration Law. So, extension of stay. So, in the case of non-immigrant visa holders whose stay in the Philippines will exceed 59 days, the consular officer shall advise them that they should secure extension of stay and register with the Bureau of Immigration and pay for the necessary immigration fees. So, ang extension of stay is kani ang murag mo provide og so ang extension of stay is kani ang makatabang nimo para mataas-taasan pa imong pag-stay diri sa Pilipinas if you're a non-immigrant visa holder. So like for example, si John, si John is a non-immigrant visa holder. So iyang visa is galawang 30 days to stay here, but John realized nga he need to stay, so extend his stay here in the Philippines for more than 60 days to complete his business project. So John need to register or secure extension of stay with the Bureau of Immigration para ma matastasan pang stay niya diri sa Pilipinas. So if makafile na siya application, so the immigration officer will review his application, and if it approves, so John can stay for 90 days a total here in the Philippines. So the entry and the admission of an alien are matters of privilege, and there is no duty on the part of the Commissioner of Immigration to extend the stay of a temporary. So the power of the Commissioner of Immigration to extend the stay of a temporary visitor, ministerial visitor, is plenary. He is vested with the power and authority to grant such extension. So therefore, the Secretary of Foreign Affairs is not authorized to admit into the Philippines aliens for temporary stay or to extend the temporary stay of alien visitors in the country, as the law bears such power in the Commissioner Immigration. So, application of the law as expressed. So, for the case, Chang Yufa was admitted to the Philippines on pre-arranged employment immigrants under Section 13A of the Philippine Immigration Act of 1940. So, with the condition that his stay shall be limited to 2 years, and should be he failed to comply with said condition after the expiration of the period, he shall be subject to deportation. Chang Yufa consisted to such condition. Is such condition within the power of the Commissioner of the Immigration to impose? So, in the legal opinion, so yes, so the such condition is within the power of the Commissioner of Immigration to impose. The power of the Commissioner of Immigration under Section 20 of Commonwealth Act number 613 should include the authority to impose such limitation. For if the Commissioner has the power to deny completely the admission of an alien who seeks to enter this country on a pre-arranged employment by withholding the issuance of an immigration visa on the ground of public interest, so with more reasons can he impose a condition which is less onerous, such as limiting the duration of his stay in the country. So having consented to his admission under such condition, Chang Yu-fa cannot now be heard to complain that the Commissioner of Immigration acted in excess of his power in imposing that limitation. So Chang Yu-fa is now under estoppel from disputing such power. So the next topic is the exclusion of foreigners. So the law, Section 29A, the following classes of aliens shall be excluded from the country into the Philippines. So this law is for the exclusion of foreigners nga kanang someone or person who cannot enter into the country. So because of the following: the first, idiots or insane persons and persons who have been insane. So number 2, persons afflicted with a loathsome or dangerous and contagious disease or epilepsy. So these are the persons nga kanang naisakit nga makatakod. So dili sila pwede mag-enter sa country. So number 3, persons who have been convicted of a crime involving moral turpitude. So these are the persons nga kanang nakabuhat og crime from the previous country nga di siya gikan. So number 4, prostitute or procurers or persons coming from for any immoral purpose. So these are the persons nga kanang ang gi nilang is for the prostitution o kanang pagbibinta ng katawan. So number 5, so persons likely to become public charge. Number 6, foofers, vagrants, and beggars. So these are the persons nga there's no permanent homes or employment. Number 7, persons who practice polygamy or who believe in or advocate the practice of polygamy. So the next is number 8, persons who believe in or advocate the overthrow by force and violence of the government of the Philippines or of constituted law and authority, or who disbelieve in or are opposed to organized government, or who advocate the assault of or assassination of public officials because of their office, or who advocate to teach principles, theories, or ideas contrary to the Constitution of the Philippines, or advocate or teach the unlawful destruction of property, and who are members of or affiliated with any organization entering or teaching such doctrines. So these are the people that who want to kanang overthrow the by force or violence ang kanang mga government officials here in the Philippines. So gusto nila i-down ang government here in the Philippines. So next is number 9, persons over 15 years of age, so physically capable of reading, who cannot read printed matter in ordinary use in a language selected by the alien. Sorry. So number 10, persons who are member of a family accompanying an excluded alien. So unless, in the opinion of the Commissioner of Immigration, no hardship would result from their admission. So number 11, persons accompanying an excluded person who is helpless from mental or physical disability or infancy, when the protection or guardianship of such accompanying person or persons is required by the excluded person, as shall be determined by the Commissioner of Immigration, if otherwise admissible. So number 12, children under 15 years of age unaccompanied by a parent, except that any such children may be admitted in the discretion of the Commissioner of Immigration, if otherwise admissible. So number 13, stow, stowaways, stowaways, except that any stowaway may be admitted if in the discretion of the Commissioner of Immigration, if otherwise admissible. So the persons coming to perform an unskilled manual labor in pursuance if of a promise or offer the employment express if or implied. But this provision shall not apply to persons bearing passport visas authorized by Section 20 of this Act, so as amended by the Republic Number 503 of Section 10. So number 15, So the persons who have been excluded or deported from the Philippines, but this provision may be waived in the discretion of the Commissioner of Immigration. So provided, however, that the Commissioner of Immigration shall not exercise his discretion in favor of aliens excluded or deported on the ground of conviction for any crime involving moral turpitude. 6 of this act, or on the ground of having engaged in hoarding, black marketing, or profiteering, unless such alien have previously resided in the Philippines immediately before their exclusion or deportation for a period of 10 years or more, or are married to a native Filipino woman, as amended by Republic Act No. 503 in Section 10. So number 16, persons who have been removed from the Philippines at the expenses of the government of the Philippines as indigent aliens under the provision of Section 43 of this Act, and who have not obtained the consent of the Board of Commissioners to apply for readmissions, and number 17, persons not properly documents for admission as may be required under the provision of this Act. So, discussion of the law. So the international law affords sovereign states absolute discretion to determine whether or entry depends on whether he or she poses a risk to the general welfare. So if an alien's entry will get an alien is disqualified for entry into its territory. As a general rule, an alien's fitness for threatened national security, public safety, public health, and public morals, then the state can declare such aliens as being ineligible for entry. So laws, rules, and regulations. The purpose of exclusion is to ensure the aliens who are allowed exclusion is defined as immigration entry into the Philippines do not pose as threats to any of the three major categories of exclusion. So the ground, namely public safety, public health, and the national security. So as a general rule, an order for exclusion is final and executor, and bars the alien from entry or the admission into the Philippines unless waived by the Commissioner of Immigration under Section 29 of the Philippine Immigration Act of 1940. So in all cases, the burden of proof is upon the alien to establish under oath before the immigration officer or the Board of Special Inquiry that he does not fall in any of the categories of excludable aliens under Section 29. Application of the law. So the case, the three petitioners, Dolores, Felix, and Manuel, all surnamed Neria, arrived in Manila from Hong Kong on board Cathay Pacific Airways on July 9, 1961. So the matter of the admission of Dolores, Felix, and Manuel Neria was referred to the Board of Special Inquiry Number 1, which on August 2, 1961, after investigation, found Dolores Neria to be a Filipino citizen and Felix and Manuel Neria to be her illegitimate minor children by a Chinese national, Gan Chongbing, and accordingly voted to admit them. So pursuant to Section 27B of the Philippine Immigration Act of 1940, the decision admitting Dolores, Felix, and Manuel Neria was forwarded to review by the to the Board of Immigration Commissioner. So there was no evidence of any hearing by the Board of the Commissioner. However, the identification certificates is issued to Dolores, Manuel, and Felix Neria on September 1, 1961, explicitly and uniformly recite that they had been admitted as citizens of the Philippines as per decision of the Board of Special Inquiry dated August 2, 1961, so duly affirmed by the majority members of the Board of Commissioners on August 8, 1962, or a period of 1 year from the decision of the Board of Commissioners has lapsed, a new Board of Immigration Commissioners renewed the proceedings of the Board of Special Inquiry with respect to Dolores, Felix, and Manuel Neria, and, finding that they have not satisfactorily established their claim to Philippine citizenship, ordered them excluded as aliens not properly documented for admission pursuant to provision of Section 29A, 17 of the Philippine Immigration Act of 1940, and returned to the fort where they came or to the country of which they are nationals. On July 23, 1961 and 1965, the Commissioner of Immigration issued a warrant of exclusion under Section 27B of Philippine Immigration Act of 1940 for the apprehension and eventual deportation of the petitioners. To discuss the validity of the issuance of the warrant of exclusion by the Commissioner of Immigration against petitioners in area. For the For the answer of the question, so such warrant of exclusion is null and void. It has been ruled that decision of the Board of Special Inquiry becomes final if it is not appealed to, so renewed or revised by the Board of Commissioners within 1 year from its promulgation. Since the Board of Commissioners promulgate a new decision only after a period of 1 year has lapsed, it is it is but a proper it is promulgate it is but proper to commence deportation proceeding under Section 37 of the Philippine Immigration Act of 1940. Accordingly, no warrant of arrest should be issued by immigration authorities before a final order of deportation is made, for until it is established that an alien lawfully admitted gained entry into the country through illegal means, and his expulsion is finally decreed, his arrest cannot be ordered. So the issuance of warrants of arrest be by the Commissioner of Immigration solely for purposes of investigation and before a final order of deportation is issued conflicts and with Article 3 Bill of Rights of our Constitution, providing the rights of people to be secured in their persons against unreasonable searches and seizures. So the next topic is the deportation of foreigners. So the law section 37A, the following aliens shall be arrested upon the warrant of the time of the Commissioner of Immigration or any of other officer designated by him for the purpose of an offence, and the warrant of the Commissioner of Immigration after the determination of by the Board of Commissioners of the existence of the grounds for deportation charges against deported aliens. So, ang deportation of foreigners is kaning nga law is kanang pag-deport sa mga foreigners or non-Filipino tourists if they are doing an illegal or crime that or they did not follow the law here in the Philippines. So the first is any alien who enters the Philippines after the effective date of this act by means of false and misleading statements or without inspection and admission by the immigration authorities at the designated port of entry or any place other than at the designated port of entry as amended by the Republic Act number 503 section 131. So number 2, any alien who enters the Philippines after the effective date of this act who was not lawfully admissible at the time of entry. So number 3, any alien who after the effective date of this act is convicted in the Philippines and sentenced for the term of 1 year or more for a crime involving moral turpitude committed within 5 years after his entry to the Philippines, or who at any time after such entry is so convicted and sentenced more than once. So number 4, any alien who is convicted and sentenced for violation of the law governing prohibited drugs as amended by the Republic Act number 503 section 13. So number 5, any alien who practices prostitution or is an inmate of a house of prostitution is connected with the management of a house of prostitution or a prosecutor. Number 6, any alien who becomes a public charge within 5 years after entry from causes not affirmatively shown to have arisen subsequent to entry. So number 7, any alien who remains in the Philippines in violation of any limitation or condition under which he was admitted as a non-immigrant. So number 8, any aliens who believe in, advises, advocates, or teaches the overture to oppose the violence of the government of the Philippines or of constitute law and authority, and who disbelieves in or is opposed to organized government, and who advises officials because of their offices, or who advises, advocates, or teaches the unlawful destruction of property, and who is a member of or affiliated with any organization entering advocation or teaching such doctrines, and or who in any manner whatsoever lends assistance, financial or otherwise, to the dissemination of such doctrines. So number 9, any alien who commits any of the acts described in section 45 of this act, independent of criminal action which may brought against him, provided that in the case of alien who, for any reason, is convicted and sentenced to suffer but imprisonment and deportation, so the said alien shall preserve the entire period of his imprisonment before he is actually deported. So, number 10, any alien who, at any time within 5 years after entry, shall have been convicted of violating the provisions of the Philippine Commonwealth Act number 653, otherwise known as the Philippine Alien Registration Act of 1941, now Alien Registration Act of 1950, Republic Act number 562, as amended, or who at any time after entry shall have been convicted more than once of violating the provisions of the same act, so added pursuant to reflect to Republic Act Number 503, Section 13. So number 11, any alien who engage in profiteering, hoarding, or black marketing independent of any criminal action which may be brought against him, added pursuant to Republic Act Number 503, Section 13. So 12. Any alien who is convicted of any offense finalized under Commonwealth Act Number 473, otherwise known as the Revised Naturalization Laws of the Philippines, or any law relating acquisition of Philippine citizenship, added pursuant to Republic Act Number 503, Section 13. So number 13, any alien who defrauds his creditor by absconding or alienating properties to prevent them from being attached or executed. So, the discussion of the law. So, the above charges are grounds for deportation under the Philippine Immigration Act. Deportation is the expulsion of the foreigner from the territory of a state. It admission of a residence in our country but whose presence therein has become untenable because of some serious infractions of the municipal law of such country. So the right of the state to admit aliens includes the right to expel them. So the right is absolute and unqualified. The power to deport aliens is an attribute of sovereignty and is based on the accepted maxim of international law that every sovereign nation has the inherent power to forbid the entrance of foreigners within its dominions. So, deportation of foreigners may be affected in two ways. So, by order of the President after due investigation pursuant to the old 1917 Administrative Code, Section 69, and through the Commissioner of Immigration upon recommendation by the Board of Commissioners under the Philippine Immigration Act of 1940, Section 37A. So in our jurisdiction, the power to deport lies with the President of the Philippines or through its authorized agent, is either Commissioner of Immigration. So the power to deport or plenary in nature and is free from any interference on the part of judicial power. So no alien shall be deported without being informed of the specific grounds for deportation, nor without being given a hearing under rules of procedures to be prescribed by the Commissioner of Immigration. So in deportation proceeding involving the entry of an alien, the burden of the proof shall be upon the alien to show that he entered the Philippines lawfully, and the time, place, and manner of such entry, and for this purpose he shall be entitled to a statement of the facts in connection with his arrival as shown by any record in the custody of the Bureau of Immigration. So, application of the law. So the case, petitioners Andrew Harvey and Johnny Sherman, 52 and 72 years respectively, are both American nationals residing in Pagsanhan, Laguna, while Adrian Van Elschot, 58 years old, is a Dutch citizen also residing in Pagsanhan, Laguna. So the case stemmed from the apprehension petitioner on 27 February 1988 from their respective residence by agents of the Commission on Immigration and Deportation or CID of missing orders issued by Commissioner Miriam Defensor Santiago of the CID. So petitioners were among the 22 suspected alien pedophiles who were apprehended by virtue after 3 months of close surveillance by CID agents in Pagsanhan, Laguna. So seized during petitioners' apprehension were rolls of photo negatives and photos of the suspected child prostitutes shown in salacious poses as well as boys and girls engaged in a sex act. So there were also posters and literatures advertising the child prostitute. So on March 4, 1988, the deportation proceedings were instituted against petitioner for being undesirable aliens under Section 69 of the Revised Administrative Code Deportation Case number 88 to 13. So on March 7, 1988, warrant of arrest were issued by CID Commissioner Santiago against petitioners for violation of Section 37, 45, and 46 of Immigration Act and Section 69 of the Revised Administrative Code. So on the same date, the Board of Special Inquiry commenced trial against petitioners. So is the issuance of the warrant arrest by Commissioner Santiago pending the existence of probable cause in an administrative deportation proceeding valid? So in the legal opinion, so the issuance of warrant of arrest by Commissioner Santiago is considered valid. So probable cause has been defined as referring to such fact and circumstances antecedent to the issuance of the warrant that in themselves are sufficient to induce a cautious man to rely on them and act in pursuance thereof. So the People versus Sijuko 64, Philippines 667 in 1937, or Alvarez versus CFI 64, Philippines 33 on 1937. So in this case, the arrest of petitioners was based on the probable cause determined after close surveillance for 3 months, during which period their activities were monitored. So the during the which period their activities so during existence of probable cause justified the arrest of the seizure of the photo negatives, so the photographs and posters without warrant. Those articles were seized as an incident to a lawful arrest and are therefore admissible of evidence. So Section 12, Rule 126 on 1985, Rules on Criminal Procedure. So assuming that the arrest of petitioner was not valid at its inception, so the records show that formal deportation charges have been filed against them as undesirable aliens on March 4, 1988. Warrant of arrest were issued against of them on March 7, 1988 for violation of Section 37, 45, and 46 of the Immigration Act and the Section 69 of Administrative Code. A hearing of presently being conducted by a Board of Special Inquiry. So the restraint against their person therefore has become legal. The writ has served its people, so the process of the law is being followed. So that's it for my part, and for the next reporter is Miss Justine Claret Piscadero. Thank you everyone for watching, and God bless.